Welcome to the Deep Dive, the place where we cut through the noise, bypass the jargon, and really get straight to the strategic core of even the densest source material.
That's right.
Today, we're taking on a pretty vital mission, wading deep into a high-stakes legal situation where it really looks like intentional clutter and, procedural trickery are the main weapons.
It's absolutely the case.
Yeah.
Our focus today isn't just on the outcome of a case, but on the method of the attack.
Right.
We're investigating a landscape where the rules, the procedural rules, and the integrity of digital documents, the very foundation of the justice system, have allegedly been weaponized.
So what are we looking at specifically?
We're going to be digging into reports related to an appellate court filing with a real focus on these detailed allegations of tampering within the electronic filing system, which is Tyler Tech.
Okay.
And then we pivot to analyze a genuinely alarming clause found inside a contested court order, specifically one that tries to instruct and even grant immunity to Texas law enforcement officers.
And here's the mission statement for you, the listener. This isn't just about understanding a lawsuit. It's about seeing a systemic attack on due process. This deep dive is going to reveal how these tiny, seemingly small procedural mistakes, like a single typo in a judge's name or a contradictory email, are being analyzed by some advanced legal intelligence as calculated moves.
Calculated moves in what our sources call a high-energy situation.
Exactly. And if these alleged actions are left unchecked, they could expose a profound, systematic violation of due process, one that's designed specifically to deny a litigant their fundamental right to appellate review. We're pulling back the curtain on what looks like digital sabotage in the courtroom.
That's the perfect way to put it.
Okay, let's unpack this. Before we get into the appellate paperwork and the alleged digital tampering, we really need to understand the environment here.
We do.
The source material uses this really vivid analogy to frame the intense danger and volatility of this conflict. It calls it a high-energy situation.
That term, high-energy situation, is just crucial because it goes so far beyond typical legal friction.
Yeah.
You have to think about the analogy used in the sources. Going to a gas station.
Right, I saw that.
We see all those prohibitions everywhere. No smoking, turn off your engine, no cell phones. And we have to ask why.
Because gasoline is inherently a high-energy substance. You have to control every potential spark, or you get an immediate catastrophic explosion.
Exactly. The risk is immediate, and it's totally disproportionate to whatever started it. So in this legal context, the source material points to the ongoing alleged frauds, the sheer volume of these legal battles, the intense family involvement.
And the claimed judicial abuse.
All creating this intense high-energy environment. So what that means is if something happens by chance or if a procedural aspect is left, uncontrolled or unmanaged.
Even a tiny typo.
Even a tiny, seemingly inconsequential typo. The whole operation could just instantly go terribly wrong for the adversaries engaging in this alleged fraud.
I can see the parallel. In a low-energy environment, say a standard contract dispute, if a lawyer makes a typo, it's just a clerical error. You fix it, maybe you get a small sanction.
Sure.
But here, the mistake isn't a bug, it's a feature. It's designed to be leveraged instantly.
That is the strategic difference the analysis pipeline spotted. The risk is magnified because these procedural errors are allegedly being introduced deliberately. The adversaries aren't just filing motions. They are, it seems, trying to seed the system with procedural defects that can be activated later.
So they're treating the rules of court not as boundaries, but as actual weapons.
Yes. The goal isn't just to win on merit. It's to deny the opponent the chance to ever reach the merits.
So this volatility, this high energy, it focuses the attack on the most sensitive and procedural parts of the system.
It does.
Which brings us right to the Texas appellate court system, and specifically its e-filing component, Tyler Tech.
Yes. The litigant observed this highly targeted behavior. They noted that procedural mistakes were allegedly introduced into the filing after the document was officially submitted to the First Court of Appeals.
Now, if you're looking at this objectively, the first question is, how do you know this isn't just a statewide system flaw?
That's my immediate thought. Tyler Technologies manages e-filing across Texas.
Yeah.
If there's a glitch, wouldn't it be everywhere?
Exactly.
And that is the crucial distinction the source material really emphasizes. The alleged errors, the ones we're about to get into, they're attributed either to the clerk's office or maybe some localized vulnerability within Tyler Tech specific to that court.
But not system-wide.
Not system-wide. The observation is meticulous. These alleged mistakes only happened in the 2 cases involving the First Court of Appeals. The litigant has other filings, in other courts, like the 387th Trial Court, and those filings just didn't have these specific errors.
So the pattern analysis suggests the flaw isn't a statewide design defect, but it's a localized, maybe deliberate or targeted compromise of the system at the appellate level.
It eliminates the generic software glitch defense.
Right.
Exactly. This localization, it strongly supports the theory that these were calculated errors intended to lay specific groundwork for a procedural dismissal. It turns what could be a benign technical glitch into a piece of evidence suggesting a premeditated procedural attack.
Okay, here's where it gets really interesting. We're talking about localized targeting. So that means we're now investigating how the court's digital docket, the official record, might have been altered.
Subtly, digitally altered to manufacture grounds for dismissal.
And the most compelling piece of evidence here, it revolves around the name of the trial judge, Oscar Telfair III.
It does. The litigant's anti-manipulation software, which they call the legal vaccine, it flagged a critical inconsistency in how the judge was listed as an other party in the system.
What kind of inconsistency?
The source alleges that the judge's name was misspelled in the Tyler Tech parties list. Let's say, for example, misspelled by adding an extra letter, like an R.
Okay, but this needs a bit of a technical deep dive. If the litigant filed the document, the petition for writ of mandamus, why wouldn't they be responsible for that typo? I mean, doesn't the filer have to certify the party list?
That is the key question, and that's what makes this the proof of tampering, as the litigant argues. The e-filing workflow is really precise.
How so?
The litigant describes generating the service contact list before finalizing the filing. This list, which is basically the manifest for who gets served, it had the correctly spelled name of Judge Telfair.
Okay, so the service list is generated from the party list you input.
Directly from it.
So at the moment of submission, the name was correct on that critical service manifest.
Precisely. So the litigant's conclusion was, since the service manifest showed the correct spelling right at the point of submission, the change, the misspelling in the main parties list, it had to have happened after the filing was accepted and logged by the clerk.
And can a litigant go back in and edit that?
No. And that's crucial. In the Tyler Tech system, once a document is officially filed, you, the litigant, cannot unilaterally edit or correct party names. Only the clerk's office has the power to do that post-filing.
So that digital fingerprint points directly to an action inside the court's administrative sphere.
It does.
And the consequence of a misspelled judge's name, or a misnomer in legal terms, is way more than just embarrassing, especially in a petition for writ of mandamus where the judge is the respondent.
Oh, absolutely. The writ of mandamus, it requires service on the judicial officer who allegedly committed the abuse, in this case, Judge Telfair.
Yeah.
So the consequence of a misspelled name in the official registry is strategic.
How so? What's the strategy?
First, it means the system might not recognize that person as the sitting judge, so it pushes him into this generic other party category, which has different service rules. Second, and this is far more devastating, a misspelling or an incorrect party name is the classic textbook justification for a procedural dismissal. You can just throw the lawsuit out on grounds of failure to join a necessary party or improper service.
And that effectively denies appellate review on a technicality.
Before it even starts. So the alleged tampering seems designed to create an instant, fatal procedural defect that only the clerk had the power to introduce.
Wow.
And that's not all. This alleged tampering was immediately followed by a second, equally sophisticated procedural landmine: the contradictory acceptance of the filing.
Tell us more about this. This sequence seems like a crucial point of strategic deceit.
It happened on a Friday morning, right after the petition for writ of mandamus was e-filed. The litigant gets an immediate email from the clerk through the Tyler Tech system, and it explicitly states the filing was accepted.
So you'd think you're good to go. Deadline met.
You'd breathe a sigh of relief.
Yeah.
But the fine print contained the trap. The very same email had a note instructing the litigant that the names of the children must be redacted.
Wait, it was accepted, but it also needed a correction.
Exactly. And the legal vaccine software immediately flagged this action as highly suspicious and totally inconsistent with standard procedure, especially for pro se litigants.
What is the standard procedure then?
Standard procedure when you're facing a correctable error, like a redaction requirement, is for the clerk to reject the filing.
Reject it, not accept it.
Right. That rejection tells the filer the clock is stopped, and they get a short window, usually about 10 days, to fix the flaw and resubmit it.
So why is rejection the standard, and why is accepting it with a noted flaw so problematic?
Well, the difference is critical for appellate deadlines. When a filing is rejected, you get a chance to fix the error without losing your filing date.
Okay, that makes sense.
But when the filing is accepted, even conditionally, it means the document is now officially logged in the system as complete. And that starts the clock on all sorts of service and response deadlines.
Ah, I see.
So by accepting the document, while at the same time noting a mandatory fixable flaw, the analysis pipeline concluded that the clerk was seeding a pretext for a dismissal.
So they accept it, they start the clock ticking on all these requirements, but they hold on to a known curable flaw that they can later use against you.
That's it. It's a mechanism to guarantee a dismissal on a technicality, regardless of the merits of your case.
It allows them to bypass the requirement to even tell the litigant that the document is technically deficient.
And instead, use that deficiency later to justify a failure to complete service, or to argue it was improperly filed, which then enables a later mootness or procedural dismissal. It's a classic bait and switch. The goal is to stop the case from ever getting past that first procedural hurdle.
So let's just synthesize what we have so far. We have this highly volatile legal environment, a misspelled judge's name allegedly introduced post-filing, and a contradictory acceptance email. All these procedural flaws seem explicitly designed to just manufacture grounds for dismissal, to guarantee that the substantive appeal never sees the light of day.
And that synthesis leads us right into the analysis of the service failure. Because despite the petition for writ of mandamus being accepted, even with that noted flaw, the appellate court clerk served the two opposing attorneys and the litigant.
But not the judge.
But allegedly failed to serve Judge Telfair, who was clearly listed as the necessary judicial party in the mandamus action.
But if the judge's name was indeed misspelled in the official party list, couldn't the clerk just claim they couldn't identify him correctly to serve him? Was the misspelling the justification?
That is the exact trap the legal vaccine analysis exposed.
Oh, so.
If the judge's name was misspelled as alleged, the Tyler Tech system might not correctly identify him as the active judge of the 387th Court. It might just classify him as an other party.
Okay.
But the analysis confirmed that even as an other party under the procedural rules, he absolutely should have been served, regardless of his judicial title.
So they were doubly cornered. If the name was correct, they failed to serve the necessary judge. If the name was misspelled, they failed to serve a necessary other party.
It's a checkmate scenario on service requirements. The combination of the alleged internal system misspelling and the external non-service created a perfect, targeted procedural hole. It was designed to justify dismissing the petition because of a failure to join a necessary party.
So knowing all this, the litigant had to pivot strategically. They had to disarm these procedural landmines proactively.
They did.
What were these counterfilings? How did they work to establish a record against the court's own digital records?
Well, the litigant executed several correction filings. The first step was filing a document that explicitly memorialized the whole sequence of events.
So just laying out the facts.
Laying out the facts, stating that the name was misspelled, confirming that the litigant could not change the name post-filing, and therefore placing the responsibility for the error directly on the clerk's office.
And that act is crucial, right? It creates an undeniable factual record for any future court challenge.
It forces the court to address the allegation of system tampering head-on. You can't ignore it.
And what about the service failure? How did they address that?
They filed a highly specific and detailed certificate of service. This wasn't some boilerplate form. This document explicitly named all necessary parties, including the two appellate court judges involved, Honorable Susan Brown and Judge Telfair, and, importantly, used the correct spelling for everyone.
And the strategic intent there must have been multifaceted.
It was. By filing this detailed certificate, they definitively placed the responsibility for confirming service back onto the court's electronic system. It removed any ambiguity about whether the litigant requested proper service.
So they were essentially showing the appellate court, look, we told you exactly who needed to be served, spelling included. If service failed, the fault lies with your administrative process, not with us.
Exactly. It's about creating a paper trail that points back to the system's failure.
But despite these proactive moves, the ultimate mechanism of dismissal was even more sophisticated than a simple failure to serve. The case was dismissed as moot.
Yes. And this is where the alleged fraud comes into really clear focus. The appellate court dismissed the petition for writ of mandamus as moot. And this dismissal was entirely dependent on what the source calls a deceptive document,
Which was?
A notice of entry of temporary orders filed by the opposing counsel, Morgan Hibner and Troy Pickett.
Let's back up for a second. What was the purpose of the writ of mandamus in the first place? Why was it filed?
A writ of mandamus is a high-level request. You're asking the appellate court to compel a lower court judge to perform a required legal act.
Right.
In this case, the litigant was contesting the issuance of these temporary orders, alleging due process violations, and that the orders placed the child in danger because of some car issues. The petition was basically trying to nullify those orders or force the court to follow proper procedure.
And this deceptive document claimed the issue was already solved.
Precisely. The notice of entry of temporary orders allegedly tricked the appellate court into believing that the contested orders had already been officially signed and entered by Judge Telfair on the 10th of the month.
So if the orders were already signed, then the action the litigant was asking for was technically finished.
Which renders the entire petition for mandamus moot. It's over.
So the court got to avoid reviewing the substantive allegations of judicial abuse and civil rights violations by accepting this fraudulent premise that the orders were signed, sealed, and delivered before the mandamus could even be heard.
That is the central fraud, as described by the sources. The dismissal as moot allowed the appellate court to just sidestep the whole substance of the petition, which included really severe allegations of due process violations and an attached temporary restraining order.
It denied the litigant their fundamental right to appellate review.
That's what it comes down to. And furthermore, the litigant noted a key fact on the docket of the 387th Court. Judge Telfair allegedly signed the orders on the exact same day that he had scheduled a hearing to contest them.
Wow.
Which just reinforces this view that the mootness trap was a bait-and-switch designed to eliminate any appellate scrutiny.
Okay, so we're shifting now from the process, the weaponized procedural code, to the substance of the alleged abuse.
Yes.
We have to examine the actual content of the temporary orders, specifically a clause that the anti-manipulation pipeline, the legal vaccine, flagged as not just questionable, but potentially indicative of profound criminal intent.
We have to transition from analyzing the digital sabotage that denied the review to analyzing the content that they were trying so desperately to shield from review.
And the source material highlights the specific, highly unusual clause.
Allegedly drafted by the opposing counsel, Morgan Hibner, and then ultimately signed by the judge. And this clause attempts to instruct Texas law enforcement and grant them explicit immunity.
Let's look closely at the language. What was the exact phrasing of this clause, and what does it reveal about the alleged operational scope of the parties involved here?
Well, the clause is titled with this very official-sounding header. Notice to any peace officer of the state of Texas. And the first part of the instruction is, a peace officer of the state of Texas may use reasonable efforts to enforce the terms of child custody specified in this order. Now, on the surface, that might sound like standard boilerplate.
Right, it sounds reasonable. Enforce the order.
Sure, but law enforcement officers are already expected to enforce valid court orders. They don't need a specific instruction in a civil order to do their jobs. The really extraordinary nature is revealed in the next section, the explicit grant of immunity.
Walk us through the immunity grant. This has to be the most legally shocking part.
It is indeed. Crucially, the clause states, and I'm quoting here, a peace officer who relies on the terms of a court order and the officer's agency are entitled to the applicable immunity against any claims, civil or otherwise.
Wait. We're talking about an attempt embedded in a civil temporary custody order to give what sounds a lot like qualified immunity to a third party, the police, for enforcing the terms of that specific order.
That's what it sounds like.
But hold on. Qualified immunity is a complex defense mechanism, right? It's granted to government officials. It's defined by state and federal statutes, case law. Is there any precedent for a private attorney operating under a state court judge to unilaterally dictate the boundaries of police authority and shield them from liability inside a temporary custody order?
That just seems like an outrageous overreach of private legal power.
It does.
And that is precisely the paradox highlighted by the source analysis. The police do not need a civil lawyer or a family court judge to tell them what their authority is or what their existing immunity protections are.
They already know the law.
Right. So by including this clause, the parties are allegedly trying to create a legal shield against potential future lawsuits that could be filed by the litigant against law enforcement for enforcing the orders. Orders which, remember, the litigant was actively contesting as fraudulent and unconstitutional.
So it suggests they were anticipating civil liability, and they were making an aggressive, preemptive attempt to insulate state actors.
That's the analysis.
So the legal vaccine must have flagged this clause as highly unusual. What did its analysis conclude about the purpose of inserting this language? What operational strategy does this imply?
It didn't just flag it as unusual, it flagged it as potential evidence of a chain of serious crimes,
Wow.
suggesting the clause serves primarily as a powerful tool for intimidation and coercion against the litigant. The analysis pipeline really focused on the intent behind involving state actors and then trying to shield them.
Can you detail the specific potential violations the pipeline identified?
The analysis flagged potential violations ranging from tampering with a witness, the idea being to silence the litigant or stop him from filing more reports and challenges, to the more severe charge of engaging the police on a fraudulent basis.
Okay, what does that mean, engaging the police on a fraudulent basis?
The logic is this. If the underlying custody orders are eventually proven to be based on judicial fraud or deceitful filings, as the litigant alleges, then compelling or encouraging a state actor, like the police, to enforce those fraudulent orders, while you're also trying to grant them immunity, represents a significant escalation.
And how does this connect to federal law? I mean, these are often local civil issues that just stay local.
This is where the strategic depth really emerges. The conclusion from the pipeline is that this clause aims to compound the severity of eventual charges by linking the alleged judicial fraud directly to attempted law enforcement manipulation.
How does that work?
If the involved parties are found to have used the color of state law, which is exactly what a court order provides, to violate the litigant's civil rights, say due process or parental rights, they open themselves up to potential charges under specific federal statutes.
Like Title 18 violations?
Exactly. Title 18, things related to conspiracy or deprivation of rights under color of law.
So by inserting a clause that explicitly ties the power of the state, the peace officers, to an allegedly fraudulent document, they are escalating a state-level civil issue into a much more serious legal liability involving federal jurisdiction.
It's an attempt to operationalize the court as a protective shield for a criminal enterprise. That's the allegation.
It reveals a pretty deep operational plan.
It does. The source analysis concludes they weren't just trying to win the custody battle, they were allegedly trying to neutralize all potential external challenges, including future civil suits against the police, by drafting their own immunity clause into the judicial order.
And the litigant noted that this clause was unilaterally proposed and inserted into the final order by the opposing counsel.
Yes, not something the judge specifically mandated verbally in court, which just emphasizes the private strategic nature of its insertion.
This entire deep dive really hinges on the ability of the legal vaccine, this advanced software system, to see intentionality where others just see clerical error. And the software isn't just analyzing filings, it's guiding the strategic response. It's even guiding decisions around leveraging human intelligence from inside the adversary network itself.
Which brings us to a critical strategic and ethical puzzle the litigant faced regarding informants.
Exactly. This section moves us from document analysis to, well, to strategic intelligence warfare.
It really does. The litigant was getting actionable, critical intelligence from a source described as a Venezuelan informant, someone allegedly connected to a network linked to significant international figures.
And this intelligence was vital for dismantling the alleged local criminal enterprise.
It was. But the ethical and legal dilemma for the litigant was immediate. Is it okay, ethically or legally, to reward this person financially for providing information that helps you dismantle a criminal enterprise that is attacking you?
You're paying someone who is inside the enemy camp.
It creates a tremendous internal conflict, right?
Yeah.
Especially since the informant's network is described as hostile. The litigant needed a clear legal and strategic justification.
And this is where the legal vaccine pipeline was engaged to process this really complex moral, legal, and operational question.
It was.
So what was the software's framework for analyzing this? Was it just a simple legal compliance checklist, or was it a deeper ethical model?
It went much deeper than just compliance. The software's resolution was clear, but also highly conditional.
What was the conclusion?
That rewarding the informant is not legally punishable, provided the litigant is not assisting the informant in committing any criminal activity, and the reward is tied to the successful prosecution or recovery related to the information provided.
That distinction seems key.
It is. The system framed the transaction not as payment for espionage, but as compensation for actionable intelligence that leads to the restoration of due process and the capture of alleged criminals.
And what was the underlying strategic and, I guess, philosophical rationale that allowed the legal vaccine to greenlight this?
The rationale was based on this concept of societal value creation. The system concluded that the informant's information, by helping a litigant expose and stop people who are committing crimes and disrupting the rule of law, actually adds massive value to society.
A net positive.
A net positive flow of economic, social, and judicial value to what the sources call the real society. So therefore, the reward is justified and non-punishable because it directly promotes a positive societal outcome, the restoration of legal integrity.
This analysis then connects to a highly philosophical but strategically relevant concept the sources call the communist paradox.
It does.
And that seems like a massive conceptual leap from rewarding an informant to philosophical communism. How does that linkage work?
Well, it's an important intellectual justification for the entire strategy. The communist paradox, as the sources define it, suggests a societal breakdown where success, reward, and wealth, they don't correlate with genuine societal contribution or merit.
Right.
So when the alleged criminal network operates, which the sources term the bizarro state, they are actively disrupting that meritocratic principle. Their success isn't derived from creating value, but from leveraging fraud, coercion, and alleged judicial compromise for their own private illicit gain.
So, in this bizarro state, the bad actors get rewarded while the good actors suffer, reversing the natural flow of merit and consequence.
Exactly. The system is designed to reward non-merit. By successfully using the informant's help, the litigant aims to expose this criminal enterprise, which could lead to regulatory action, criminal prosecution.
And potentially the recovery of financial damages or receiving substantial reward.
Right. For instance, through things like IRS whistleblower avenues if there's financial fraud involved.
And this reward mechanism then reverses the paradox by tying the compensation back to a positive societal outcome.
Precisely. The subsequent positive flow of value-recovering funds, disrupting crime, is directly aligned with genuine merit that benefits the real society. The compensation or reward is tied directly to the positive outcome, disrupting the criminal operation, which acts as a functional mechanism against the paradox.
So it justifies the action not just legally, but as a mechanism for self-defense and for restoring societal integrity.
It does. It ties compensation to positive social impact, not illicit gain. And this intellectual framework allows the litigant to confidently leverage intelligence from within the enemy camp, knowing they're working to align the system back toward genuine merit.
So this whole deep dive has really exposed the operational depth of what you called a high-energy legal conflict. We've seen how the procedural code itself is allegedly weaponized.
Used by filing deceptive documents and manufacturing these procedural flaws, like the intentional misspelling of a judge's name in a digital system.
Which all leads to that devastating mootness dismissal.
And the technological analysis from the legal vaccine, it acts as the essential shield. It reveals the profound intentionality behind what are supposed to be administrative mistakes.
The most chilling takeaway for me, though, remains the operational depth of this alleged criminal network. I mean, it's chillingly illustrated by the fact that these contested temporary orders contained language explicitly trying to instruct and grant immunity to Texas peace officers.
For enforcing those very orders.
This is so far beyond routine legal maneuvering. It suggests an attempt not just to win a case, but to co-opt the authority of state actors, the police, for protection and enforcement against any future challenges.
Absolutely. The discovery of this specific clause, which attempts to unilaterally confer immunity to Texas peace officers and their agencies for enforcing these highly contested, allegedly fraudulent orders, it compels a final critical consideration for all of us.
And what's that?
We have to ask ourselves, what are the jurisdictional and ethical limits when a private lawyer, operating on behalf of a state court judge, attempts to dictate the boundaries of police authority and shield those officers from civil liability?
It's a fundamental question.
It is. This specific action raises fundamental questions about the scope of judicial overreach, the separation of powers, and the potential corruption of local institutions that we have to continue to scrutinize.